Gary Wall here, and this is Bridging the Week for January 19th to 23rd, and today is January 26th, 2015. Good morning. The fallout from the January 15th decoupling of the Swiss franc and euro by the National Bank of Switzerland continued to have wide regulatory and legal reverberations last week. In addition, Chicago Mercantile Exchange Group exchanges resolved a cornucopia of disciplinary actions touching upon rules related to block trades, automated trading systems, disruptive trades, and wash sales. A lot happened last week, so let's get started. Following the unexpected decoupling by the Swiss National Bank of the Swiss Franc-Euro exchange rate on January 15th, the subsequent meteoric rise of the Swiss franc against the euro, and to a lesser extent the US dollar, and the financial difficulty experienced by at least two international retail foreign exchange dealers, exchanges, and at least one regulator, instituted a number of interim measures and promised more. Among measures taken by exchanges and one regulator, the National Futures Association increased the minimum security deposit required to be collected by forex dealing members for trading in 8 foreign currencies by retail clients, including from 2% to 5% for transactions involving Swiss francs. A panel of the Chicago Mercantile Exchange's Misconduct Committee, on an emergency basis, granted additional authority to the CME Group Global Command Center regarding price fluctuation limits on certain CME products, including CME foreign exchange futures and options. The emergency action permits the Global Command Center to modify the amount of price limit expansions, remove price limits at any time, and determine whether a specified trading halt will be instituted, among other authority. The CME Group also proposed to amend its rules to grant the Global Command Center the permanent authority, quote, in its absolute and sole discretion, to take any action it determines necessary to protect market integrity, quote, including the type of actions accorded the Global Command Center through the emergency action in the context of price fluctuation limits, and ICE Futures US includes reasonability limits for all emergency pair futures contracts. Because of the Swiss National Bank's decoupling, at least two firms maintaining substantial retail clientele trading foreign exchange experienced significant losses and capital issues as a result of their clients' trading losses, causing one based in the United Kingdom, Alparic UK Limited, to initiate an insolvency proceeding last week. The other, Forex Capital Markets, commonly known as FXCM, a CFTC-registered foreign exchange dealer, futures commission merchant, and provisionally registered swap dealer, received a $300 million infusion from Leucadia National Corporation, quote, to meet its regulatory capital requirements and continue normal operations, end of quote, after losing $225 million. Let's see how this story ends. Exchanges of the Chicago Mercantile Group imposed numerous sanctions against members and non-members related to violations of a cornucopia of rules related to wash trades, block trades, and conduct of the nature of spoofing, among other prohibited conduct. One firm was also fined in connection with its automated trading system breakdown. There are too many details to fairly describe this matter in this video, so check out all the relevant facts in the article version of Bridging the Week on the website. However, each of the described disciplinary actions points to the need for repetitive training to trading and operations staff regarding the nuances of exchange rules regarding position reporting and trade practices. Moreover, where certain non-competitive trading is authorized by exchanges, for example, block trades, exchange for related positions, and pre-execution communications, traders must be reminded frequently of the specific requirements of such authorizations. Violations of these requirements potentially violate not only the relevant exchange's rules, but applicable law and rules of the Commodity Futures Trading Commission that prohibit non-competitive transaction unless expressly done in accordance with exchange rules. Standard & Poor's Rating Services resolved enforcement actions by the Securities Exchange Commission, the New York Attorney General, and the Massachusetts Attorney General by agreeing to pay aggregate sanctions of $77 million, among other sanctions, including a one-year timeout from rating certain commercial mortgage-backed securities. The SEC actually filed and settled 3 separate enforcement actions against the S&P. Separately, the SEC commenced an administrative proceeding against Barbara Duca, who at the relevant time was in charge of S&P's team that was responsible for the activities underlying at least one of the SEC's action against S&P. The Financial Conduct Authority fined the former chief executive and chief compliance officer of Martin Brokers UK Limited for compliance and cultural failings at the firm. David Kaplan, the former CEO, agreed to pay a fine of the equivalent of $315,000 US, while Jeremy Kraft, the former CCO, agreed to pay a fine of the equivalent of approximately $155,000 US. Both individuals also consented to an order prohibiting them from performing any so-called quote-unquote significant influence function in connection with any FCA-regulated activity going forward. Previously, both the CFTC and the FCA settled enforcement proceedings against Martin Brokers, and in the case of the CFTC, RP Martin Holdings Limited II, claiming that the firms participated in the attempted and actual manipulation of the official fixing of the London interbank offered rate from at least September 2008 through August 2009. The CME Group is proposing to amend its rules expressly to prohibit violations of position limits on an intraday basis. CME Group exchanges have routinely applied its prohibition against maintaining positions in violation of position limits, both on an intraday and end-of-day basis, consistent with how the CFTC and other exchanges apply their equivalent prohibitions. Simultaneously, the CME Group is proposing to eliminate express prohibition against making bids or offers that, if accepted, would cause a position limit violation. Instead, the exchange suggests that such bids or offers might be deemed quote-unquote disruptive and contrary to express prohibition against disruptive trading or a general offense. CME Group's proposed amendment is expected to be effective February 6. And finally, Scottrade Inc. agreed to pay a fine of US $200,000 and various undertakings to resolve an enforcement action brought by the Financial Industry Regulatory Authority regarding the firm's alleged unauthorized sharing of information related to 300,000 customers in connection with a class action litigation. According to FINRA, on 36 occasions in 2012, Scottrade disclosed the names and addresses of the customers in violation of an applicable SEC rule, Regulation SP, that generally prohibits disclosure of non-public customer information unless a customer receives proper notice and an opportunity to opt out of the disclosure, and related rules of FINRA and its predecessor, NASD regulation. Well, that's it for this week's Bridging the Week. As always, there's more information in each article, and more articles on the article version of Bridging the Week are on the website. Until next week, this is Gary DeWall. Have a great week, and ciao!